welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Michael Desmarais. Michael is an attorney with a law practice here in Los Gatos, California, in the heart of Silicon Valley. He's a highly respected estate litigation attorney here in Silicon Valley. Received his JD degree from Hastings College of Law at the University of California in 1973. His honors included the Order of the Coif. He is a certified specialist in probate, estate planning, and trust law. And among his many distinctions, he's the past president of the Silicon Valley Bar Association and a fellow of the American College of Trust and Estate Counsel. Mike is also the author of the Litigation Tools chapter of the California Trust and Probate Litigation book published by California Continuing Education of the Bar. And today, Mike and I are going to be talking about estate planning for second marriages. Now, before we get started, I just want to caution our viewers again that we're talking about a complex area. They have whole courses about this in law schools. This is a very complex area, so please get independent legal counsel. Michael is a California attorney who principally works on lawsuits involving estates and trusts, and I'm a California CPA. So we know about California stuff. If you live in another state, you may have special rules that apply to you that you need to be aware of and get that professional help. Mike, thanks for being my guest today.
Thank you for having me, Mike.
Okay, let's get started with some of these questions. All right, Mike, you do a lot of estate litigation work. You're the first one they look for when they come in the courtroom, the last one they hope to see. Do second marriage questions come up a lot in your estate litigation practice?
They certainly do.
Okay, why is that?
It's one of the few growth areas, if you want to call that, as far as attorneys are concerned. There seems to be an enormous amount of wealth in our parents' generation. Especially in this valley. And there are a large number of second marriages. I think the divorce rate is over 50%. And you frequently have children by the prior marriage, and there are issues that come up after the second spouse dies, sometimes after the first spouse dies, about who's supposed to get how much of what. And it's often more difficult when the man is the second spouse to die, because, as you know, Mike, men are not very well interdirected like our spouses are.
Okay, so my next question is, do all deaths, maybe we can say, do you think a very high percentage of deaths of spouses in second marriages result in litigation?
Yes, I think they do. Basically, if you own a house in this valley, you're often got an estate worth $1 million or more. And the issues that come up about whether it was your community, your father's community property, or your stepmother's separate property, or who inherited what from whom, often comes up, and there's a fight over who's supposed to inherit it.
Yeah. Okay. So what are the common factors for most litigation in this area?
Well, usually what happens is that men just can't stand to be alone in the second half of their lives. So they'll marry their second wife / nurse, tell her one thing, and they'll tell the children by the prior marriage the opposite to keep both sides happy. And then they can die in peace, and the children didn't trust the second spouse to begin with, and the second spouse doesn't trust the children. And there become fights over, gee, you shouldn't be inheriting not only our father's money, but our mother's money, because when our mother died, she left it to our father. So it can be either because the first marriage ended in divorce, or it ended with a death, but somehow the children by the prior marriage think that they are entitled to something. Plus, you have to keep in mind, Mike, that a lot of today's children, our children, are not as interdirected as we were. Now, maybe that's partly because they don't have the same economic opportunities that we have. It's tougher to get into school. It's more expensive to get into school. Once you get out, it's tougher to find a job. The economy is in a recession, or maybe it's coming out of it. I'm not sure, one way or the other. But the children are often looking to their parents to supply them with the same lifestyle that they were acclimated to during their minority. And it's often a lifestyle they can't supply for themselves. And so they don't see their parents' money as their parents' money to do with as they please. They see it as their future inheritance. The bottom line is that when you get married to someone, what you bring into the marriage is your separate property. And while you're married, if you inherit something or receive a large gift, that's separate property. But pretty much everything else is community property, your earned income, wages, salaries. And then for people that have closely held businesses, if you work in the business but are paid a very low compensation from it, there becomes an issue as to whether or not your compensation is clearly community property. But if you're paid less than the value of your services, maybe some part of that separate property business should become separate property. Now, these are often issues that come up in a divorce or a dissolution of marriage.
Right.
But they also come up after one spouse dies and the other spouse inherits. Most, but not all, most spouses will leave their money to their second spouse, either outright or in something that is commonly called a QTIP trust. It stands for Qualified Terminable Interest Property Trust. It was originally developed as a result of the outgrowth of what was called the 1980 Economic Recovery Tax Act, ERTA. But it was done originally to save taxes, but it really worked very well for second marriage situations, or at least the theory was that it would.
Right.
For example, if I died first and then the money went to my surviving spouse, it would go to her in a trust with, so long as she would get the income automatically, there would be no death tax, and she might be able to evade the principal in her discretion. But then when she died, whatever was left would go back to, say, my children. And hers would be the exact opposite. It would work the same way for her children. And the theory was pretty good. The problem is that the trustee of that trust was often the surviving spouse. And sometimes her attitude was, quite understandably so, I took care of this pain in the ass husband of mine for 20 or 30 years, and it's now mine to do with as I please. And because nobody has to go through probate on a trust, there is no court order or court law to enforce the terms of it. That placed the children by the prior marriage in an awkward position because they thought that the surviving spouse, their step-parent, wasn't observing the rules of the trust. She was, in effect, using it for things that weren't appropriate, maybe even giving some of it to her second or third husband, as opposed to just spending the income on herself. But what could they do about it? Well, like suppose they could go to court and file a lawsuit against her to make her stop. But lawsuits, as you know, are expensive. And at the end of that lawsuit, what did they have to show for it? They weren't entitled to anything, remember, until she died. They were the remainder beneficiaries. So they could file a very expensive lawsuit, maybe even win it, but have nothing to look forward to until after she passed away. And that was assuming that she didn't use it all up during her lifetime anyway. So that's part of the problem that happens with second marriage situations in California.
So it sounds like maybe in the second marriage that this surviving spouse trustee should look both ways before crossing the street.
Well, you could say that. Often the surviving spouse, I used to make jokes about this, about how interested your stepchildren are in your health.
Yeah, right.
But as a practical matter, remember the laws of this state in probate are enforced by judges. There are very, very few opportunities for jury trials in this area. And judges generally tend to size up the surviving spouse as the one that probably ought to get most, if not all, of the money, because let's face it, Mike, being married to somebody like you or me for 20 or 30 years, that should tell for quite a bit. And if the wife that takes care of the husband and is there for him and for the last 10 or 20 years of his life, the judges normally side or bend over in her direction.
Okay. Now, are misunderstandings for second families more common, do you think, for men or for women?
Now, I kind of already touched on that. Women generally survive men, but I would say men are less trustworthy than women. I mean, men just don't want to fight, but they don't want to engage in confrontation with their children. They're very attached to them, but they just can't stand to be alone. Men just have a hard time with that. And so if they find somebody that's willing or foolish enough to marry them, they hold on to them like grim death. And they will, of course, and I think appropriately so, what they have to offer. What do we have to offer in the second half of our lives, Mike? Basically, financial security for the women we marry. And they appropriately lead their second wife to believe that the money's going to go to them. But of course, the children don't want to hear that because they don't like the idea that you're going to be leaving your second wife some of mom's money.
And I think related to this, the shorter the time after the second marriage, the more problems probably there are. The children aren't as accepting. Like I remember that I had a senior client years ago that had a second marriage, and his children said, "We don't know this woman." And then, unfortunately, he passed away like within a year or so after he was remarried.
I'd like to tell you, Mike, that there's a common factor based upon time, but I've seen it all.
Yeah.
I mean, I've seen
Yeah.
long-term second marriages where the children by the prior marriage treated their stepmother very, very well. But then as soon as Dad died, it was kind of like, well, time for you to move out of the house and go away and leave everything to us.
Mm-hmm.
And, it seems kind of shocking that they would react that way, but that's what they do.
Yeah. So you mentioned the Q-tip as a method or an estate planning tool for avoiding these problems. Are there some other things that you would add as far as how can families try to reduce this conflict?
Well, you've heard of prenuptial agreements. There's something called a postnuptial agreement, which is the same thing except it's signed after marriage.
Mm-hmm.
But postnuptial agreements in particular are very, very hard to enforce because when you marry someone, you go from being, in effect, a stranger in the law to having what's called a spousal fiduciary duty to them. In other words, I'm under a legal obligation not to take advantage of my wife, and she's under an obligation not to take advantage of me. Of course, some people would say the very essence of marriage is undue influence, that happens all the time. But I've seen situations where the husband would basically take advantage of the wife financially for 10, 20 years, and then at the end of it, he wound up with everything, and he left it to his children, and she got virtually nothing, and that just is not right. Now, you could do a prenuptial agreement or a postnuptial agreement, but they're very difficult to enforce. The courts don't like one spouse preventing the surviving spouse from getting all of the rights that they are entitled to under the community property and spousal support and family allowance laws of California. But basically, the safest thing to do if you wanted to be sure that the spouse is not going to take advantage of your children is to appoint an independent trustee, not necessarily a corporation, but somebody like a private professional fiduciary or a close friend, a business advisor. The problem with that is that your surviving spouse won't like that. Mm-hmm. Her attitude will be, well, I can understand you putting together a Q-tip trust. I can understand you wanting to have what's left go to your children when I pass away. But I'm not too crazy about having anybody else make the decisions as to how much money I need to live on and how it gets invested and that kind of thing. Mm-hmm. And most spouses are keenly attuned to that. So often the surviving spouse gets the job. What can you do to protect the surviving spouse from what the children are doing? Well, no contest clauses used to be one of the means. But of course, no contest clauses right now have been very severely cut back in terms of their powers to do anything. Basically, the best thing for the surviving spouse to do is to consult a good lawyer after her husband passes away, just for the purpose of finding out what her powers and rights are. I mean, if the children start poking their nose into her financial affairs, how much information does she have to give to them? When they say they are entitled to some money, are they really entitled to any money? Mm-hmm. When they say you shouldn't be spending any money putting a new roof on the house, or you shouldn't be spending any money going to the south of France for a vacation, do I have to really listen to that? How much of that do I have to take into account? The purpose of trusts originally was so that you could avoid probate and avoid having to deal with lawyers. You didn't really think the lawyers were ever going to come up with something that would allow you to avoid having to deal with them.
Okay. Let's see here. Related to these Q-tips, well, let's see, I think you sort of addressed that. Why wouldn't a survivor do what he or she is supposed to do?
How long have you been married, Mike?
Almost 40 years.
Do you think that maybe Mrs. Gray would have liked to have done something different in that 40 years than we actually wound up doing?
I imagine. especially if I had more money.
But she probably didn't tell you exactly how she felt about that because she was tactful and gracious. After you pass away, there's no reason for her to be tactful and gracious anymore. So maybe she feels, and I think rightly so, that after taking care of you for 40 years, whatever's left should be hers to deal with as she pleases. If she wants to give it to the Hare Krishna Society, she should be able to do that. If she wants to buy a very expensive sports car for her next husband, she should be able to do that. Problem is that your children might not feel that way. But after all, it was your wife that was taking care of you for 40 years, not your children. And so you might think that your wife is going to be doing one thing with the money, but frankly, you're not going to be there for her to have to please anymore.